At 1 hour past midnight on the day of January 6, 2021, the soon-to-be outgoing President Trump posted the following to his Twitter account. If Vice President Mike Pence comes through for us, we will win the presidency. Many states want to decertify the mistake they made in certifying incorrect and even fraudulent numbers in a process not approved by their state legislatures, which it must be. Mike can send it back. What was the President referring to when he wrote this? What does it mean for Vice President Pence to come through for us? What does it mean for him to send it back? To begin to unravel this, let's return to the basics. The President is not really elected by the American people. In actuality, the President is selected through a series of intermediaries. Each individual state holds its own respective presidential election and then submits its results to the United States Congress. These results are referred to as electoral votes. States generally award all of their respective electoral votes to whomever won a plurality of that state's popular vote. This process, each state holding their own election, the states then sending their electoral votes to Congress, those electoral votes being counted as the final results, is referred to as their Electoral College. The presidential and vice presidential candidates who win a majority of the total amount of votes in the Electoral College are then concluded as being the official President-elect and Vice President-elect during a joint session of the United States Congress on January 6, and are then finally inaugurated on January 20th. There are further nuances to this process, such as the procedures followed if no candidate secures a majority of the votes. However, these are not as of now important to understand for the current topic of discussion. The question we must now ask is this: when the Electoral College votes are counted on January 6, exactly who is it that counts? That is, which entity is actually tasked by the Constitution with tallying the votes and, if possible, deliberating over any dispute around them that might arise? The traditional answer to this question is what I'll refer to as the Congressional counting theory. Under the soft version of this theory, the Constitution on its own leaves this answer ambiguous, but allows Congress to grant themselves this power through enacting legislation in line with the necessary and proper clause of Article 1. The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Under the hard version of this theory, the Constitution already implicitly grants this power to Congress, without any need for additional legislation to explicitly delegate it. One other version, which I shall refer to as the Pinckney theory for reasons that shall become clear later, posits that the Senate and House of Representatives count the votes as a purely ministerial act, that is, a mere tallying of the state's results, without any ability to exercise discretion or judgment to resolve any disputes that may arise. Another view on the complete opposite side of the spectrum is what has been referred to as the unilateral rejection power theory. The theory argues that the power to deliberate over the counting of the votes is solely delegated upon the presiding officer of the United States Senate, that office being held either by the President of the Senate or the President pro tempore if the former is not present. This framework is precisely that which President Trump's tweet was aligned with. Trump wished that the Vice President, who holds a dual role as President of the Senate under the Constitution's Article 1, would come through for us by asserting his alleged unilateral power over the vote count to reject the electors and electoral votes of 7 different states and send it back to those states for their respective statewide legislatures to decertify the mistake they made. With several electors gone, the winning Electoral College majority needed would now be only 228 electoral votes, 4 fewer than Trump already had. The President, then, would now meet the requirements to secure a victory in the Electoral College, and thereby another 4-year term in office. The purpose of this essay is to provide an answer as to which of these interpretations seems to be correct, and more precisely, to demonstrate the problems with the URP reading. We will examine the text of the Constitution, the historical precedent established by previous joint counting sessions, the United States Supreme Court's judicial precedent regarding the electoral count, and a selection of other miscellaneous sources that are available to this analysis. I shall finish with a summary of my conclusions and some parting comments. Article 2's line pertaining to the role of the President of the Senate, contained within the third clause of its first section, reads as follows. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and a vote shall then be counted. The 12th Amendment, replacing Article 2, Section 1, Clause 3 in 1804, copied this line without any substantive changes to the text. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and a vote shall then be counted. Focus your attention on those last few words. The votes shall then be counted. They make use of a passive voice rather than an active one. That is to say, rather than explicitly prescribing that any individual or set of individuals shall count the votes, the text limp-wristedly gestures that the votes be counted, without precisely naming any counter. This is in clear contrast to the provision that the President of the Senate shall open the certificates, which explicitly names both an action and its actor. The relative linguistic ambiguity of this counting clause gives birth to the question of with whom this role lies. Kenneth Chesebro was a lawyer who, alongside fellow attorney John Eastman, wrote a series of memos for the Trump 2020 presidential campaign for the purpose of explaining and justifying the potential usage of unilateral rejection power on January 6, 2021 by Senate President Mike Pence to reject several Biden-Harris electors, as previously articulated in the introduction. In his December 13, 2020 memorandum for the at-the-time Trump campaign lawyer Rudy Giuliani, Chesebro posited that it seems entirely sensible to read this language as granting sole power to count the votes to the President of the Senate, with the members of Congress having no ability to influence the result. The arguments that he uses to justify this claim are as follows. 1. The only person or entity doing anything here is the President of the Senate. All that is explicitly required of Congress is their presence during the counting. As such, it would be appropriate to view the clause as designating the power of counting upon the Senate President, for he is the only active role explicitly named in any clear and obvious context. 2. According to Chesebro, the House and Senate can only act separately as distinct legislative chambers, meaning that every single congressman would necessarily be powerless due to the counting of the votes occurring during a joint session of Congress, wherein both chambers are temporarily combined. 3. Congress would not logistically have enough time to deliberate over the counting of the votes, a problem which does not exist with that power of deliberation simply vested in one individual. 4. If deliberation powers were vested in Congress, then the certification of the election could potentially come to a stalemate if one house objects to a slate of votes, while the other accepts that same set of votes. Throughout his memo, Chesebro makes multiple references to a 2019 article written by election law scholar Edward B. Foley. I will directly review Professor Foley's writings in a later section. For now, let's only scrutinize Chesebro's arguments independently of that. In addition to those which were articulated in the memo, I will also address some valuable arguments against the congressional theory of counting made by New York litigator Alexander Gigante in his paper Hanging by a Thread, the Electoral Count Act's Threat to America's Democracy. Chesebro begins with a very dubious assumption. The fact that the President of the Senate is the only individual described as doing anything by no means implies that he is the individual who does everything. Indeed, it would be much more natural to read the switch from active to passive voice as an implicit taking away of any theoretical role of the Senate President in counting the votes, or at least an implicit signal that the role of counting does not solely lie within his capacity. If it had been the case that this were in his power, for what reason precisely would the text not have simply maintained that active voice throughout? The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and he shall count the votes. This method of interpreting the textual switch in voice is not without judicial precedent, as articulated in the unanimous Supreme Court opinion for the 1983 case, Russell v. United States, where Congress includes particular language in one section of a statute but omits it in another section of the same act. It is generally presumed that Congress acts intentionally and purposely in a disparate inclusion or exclusion. The significance of the passive voice in judicial interpretation was further augmented 26 years later in the case Dean v. United States, wherein the court ruled that if a statute's passive voice imposition that, if his firearm is discharged, the defendant be sentenced to a term of imprisonment, implied that the defendant's intention of discharging the firearm was not required for a guilty verdict. As such, it would be much more reasonable to suggest that the amendment, in its distinct switch in language after specifying the Senate President's role in opening the certificates, implies that the role of counting the votes lies within the only other entities it mentions, the Senate and House of Representatives. This position was well articulated many years ago in a possibly apocryphal recounting of a congressional debate during the election dispute of 1876. Professor Seeley, a few days ago, was making a very learned argument upon that part of the Constitution which says that the President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates and the votes shall then be counted. Mr. Seeley, who as a Republican was of course maintaining that Mr. Ferry, the President of the Senate, had the clear and indisputable right not only to open the votes, but to do the counting. At a particularly vigorous and eloquent point in this argument, Mr. Proctor Knott, the chairman of the committee, so the story goes, remarked, "Professor, I do not wish to interrupt you in your eloquent constitutional argument, but I want you to explain to me an invitation I have just received to dinner, the interpretation of which perplexes me a good deal. It is as follows. The pleasure of your company is requested at the dinner tomorrow evening at Vika's to meet Professor Seeley and other distinguished gentlemen. The dishes will be uncovered by the steward precisely at 7 o'clock, and a dinner will then be eaten." "Now I want you to interpret for me, Professor," said Mr. Knott. "Who is to eat the dinner, the steward, or you and I and the rest of the guests?" Although it is perceivable that the clause remains vague enough that it might not necessarily on its own delegate the counting role upon Congress, I concur with the view that the decision to change verb voices from active to passive after allocating express responsibility to the President of the Senate is more significant than a failure to add Congress in a role of express responsibility. Thus, a textual reading points us to the view that at least some sort of counting role is conferred upon Congress. If any true deliberation power exists in addition, the Senate President's involvement in it perhaps only consists in his potential ability to cast a tie-breaking vote. Chesebro's second contention, that the House and Senate can only act separately, holds some more weight than his first. If we read the 12th Amendment with the presumption that it indeed does grant Congress deliberation powers over the Electoral Count, then it could perhaps also be seen that this amendment on its own grants Congress the additional power to act jointly during the count. The amendment mandates that the count occurs during a joint session in the presence of the Senate and House of Representatives, not that it occurs during a session of a singular chamber. As such, Congress could be seen as being implicitly permitted to act jointly so as to be able to perform the task of deliberating over the counting of the votes, even if this may be only allowed under this precise circumstance. I believe that this argument only works with that assumption of congressional deliberation power, a stance which I believe is compromised by the arguments presented in sections 5 and 6. If we instead adopt a presumption of the Pinckney theory, that Congress counts the votes as a purely ministerial act, then the clause would not grant the chambers any implicit power, for they would not have any genuine power of deliberation to execute. The lack of ability for Congress to act jointly here does not in my view compromise the Pinckney theory, since this theory does not accept that there are any deliberation powers that would need this ability to begin with, merely a simple tabulation of the state's votes. This tabulation only requires that the counter read the submissions without making any judgments of their own, thereby not requiring any actions of their own. The claim that Congress would not have enough time to deliberate over the counting of the votes is incongruent with reality. Congress had previously deliberated over various objections to the counting of electoral votes during the joint sessions of 1969 and 2005. For both of these times, Presidents Nixon and Bush respectively were perfectly fine and able to take their oath of office by the intended date of January 20th. The potential of a stalemate between the two houses is not of concern. Under the supplementary rules governing the joint session introduced by the Electoral Count Act, votes may only be rejected if both houses agree to do so. If one house disagrees with the other, then the objection will simply fail, and the vote shall then be counted. When Article 2, Section 1 grants power to the Congress in its 4th and 6th clauses, it precisely uses the term the Congress. In the third clause, however, it rather refers to the Senate and House of Representatives. It is unusual that this terminology would be different if this clause is supposed to be read as conferring deliberation power upon Congress. This change in language could indicate that Congress does not count the votes at all, or perhaps that the electoral count is simply a ministerial act performed by the Senate and House of Representatives, rather than its deliberative analogue, the Congress. The 12th Amendment does not use the term Congress whatsoever, only referring to the Senate and House of Representatives. The most obvious argument against URP is simultaneously the most obvious against the Congressional theory. The Constitution does not explicitly grant any entity the power to count the votes or to deliberate over the counting thereof. When Article 1, Section 4 allows Congress to make or alter the times, places, and manner of holding elections for senators and representatives, it says so explicitly. Section 5 of the same article explicitly provides that each House shall be the judge of the elections, returns, and qualifications of its own members. For what reason would the language of this deliberation power not be reproduced in either version of the counting clause, if not for the reason of no such deliberation power over electoral votes existing? The clause's use of the passive voice, previously shown in Section 1 to compromise the URP's position, could also arguably be interpreted to demonstrate the electoral count being a ministerial act in general. Its disregard for explicitly assigning the role of counting to any entity, and failure to describe how any deliberation proceeding would occur, are both unfitting attributes for any role which is said to hold that deliberation power. Before moving on to look at the historical precedent surrounding the electoral count, I'll address a few more important points regarding the textual reading of the counting clause. Chesebro writes that when Article 2 was drafted in 1787, leaders were greatly concerned about their reputation, about whether they were perceived as honourable, both during their lives and afterwards. So there was much less concern that someone in a national legislature entrusted with power to count votes would abuse it. It seems as though Chesebro is implying here that, because the framers of the Constitution allegedly did not foresee that those entrusted with counting the electoral vote would attempt to abuse their powers, and as such did not provide any explicit prohibition on said abuses of power, then those said abuses must then not be illegal. I'm not sure that the bizarrity of this argument even needs to be elaborated on. To the next point, it should be considered what URP being applied would actually entail. Before the adoption of the 25th Amendment in 1967, the Vice President's office was quite regularly vacant. Several VPs died during their own tenure, and several others ascended to the presidency itself after that officeholder had died. As such, the presiding officer of the Senate was oftentimes the President pro tempore, selected by the Senate itself. If it truly was the original public meaning that Article 2 and the 12th Amendment removed the legislature from any role in the Electoral Count, it is strange that their framers would decide to invest that role in a legislative branch official, the President of the Senate, a role whose powers and duties regularly befell upon an ordinary member of the Senate. The only substantive change made to Article 2, Section 1, Clause 3 during its drafting was the Senate President's opening of the certificates being changed from occurring in the presence of only the Senate to occurring in the presence of both the Senate and the House. The reason for this change was that the duty of selecting a president if no candidate received a majority of the electoral votes was changed from being previously assigned to the Senate to being assigned to the House instead, thus prompting a reason for the House to be present. The scholar Michael Rosen has pointed out that Madison's recording of the draft included a semicolon between the act of opening the envelopes and that of counting the votes, which could be interpreted as indicating that these actions are partaken by different entities. Aside from Clause 3, Clause 4 did have a notable change during its drafting. It originally explicitly allowed Congress to determine the manner of certifying and transmitting the electors' votes. This part of Clause 4 was later removed in its final version, seemingly indicating that the article was leaving certification exclusively in the hands of the electors themselves. On September 17, 1787, the members of the Constitutional Convention, after having signed the then new Constitution of the United States, adopted a resolution which addressed the procedural issues as to the very first election of the President and Vice President. The United States and Congress assembled under the Articles of Confederation should fix a day on which electors should be appointed by the states which shall have ratified the same, and a day on which the electors should assemble to vote for the President, and a time and place for commencing proceedings under this Constitution. That after such publication, the electors should be appointed, and the senators and representatives elected. That the electors should meet on the day fixed for the election of the President, and should transmit their votes certified, signed, sealed, and directed, as the Constitution requires, to the Secretary of the United States in Congress assembled, and the senators and representatives should convene at the time and place assigned, that the senators should appoint a president of the Senate for the sole purpose of receiving, opening, and counting the votes for president. Since no vice president had ever to this point been previously elected, there was not yet any individual to automatically serve as president of the Senate, as would be the usual standard in every election thereafter. The Senate may appoint a president pro tempore to serve in the role of presiding officer when a seat of president of the Senate is vacant or recused. In line with this, the emphasized text in the above quotation guides the Senate to fill this vacancy. On April 6, 1789, the date on which the Electoral Count took place, the Senate appointed John Langdon, a United States Senator from New Hampshire, to serve as its president pro tempore. The Senate Journal recorded that a president pro tempore is elected for the sole purpose of opening the certificates and counting the votes of the electors of the several states in a choice of a president and vice president of the United States. After the count had taken place, the Senate Journal recorded that the President of the Senate, elected for the purpose of counting the votes, declared to the Senate that the Senate and House of Representatives had met, and that he, in their presence, had opened and counted the votes of the electors for President and Vice President of the United States. The House Journal records that Mr. Parker and Mr. Heister, the tellers, then delivered in at the clerk's table a list of the votes of the electors of the several states in the choice of a President and Vice President of the United States, as the same were declared by the President of the Senate in the presence of the Senate and of this House, which was ordered to be entered on the Journal. The Senate appointed messengers to notify President-elect Washington and Vice President-elect Adams on their respective vote certifications. The messages referred to the President of the Senate as having opened all the certificates and counted all the votes of the electors for a President and for a Vice President. The very first electoral count has been said to provide the only historical evidence that might support the view that the President of the Senate, rather than Congress, counts electoral votes. This evidence is nonetheless of limited probative value due to a number of factors. First, this election was not exactly contested. Washington was elected to the presidency unanimously, and Adams secured the vice presidency with a decisive second place. There was thus not a single dispute over any of these votes being counted, and as such, we are unable to see how any dispute resolution process would have occurred had one arisen. Second, this session occurred under the provisions of Article 2, before it was later superseded by the 12th Amendment. It would thus be more useful to examine the three latter electoral counts that happened prior to the amendment's ratification in 1804 if we are to ascertain the settled practice of counting the electoral votes that constituted the original meaning of the counting clause when the framers of the 12th Amendment drafted the provision. Third, it is not evident that, when describing the Senate President as counting the votes, the first Congress considered this role to be any more than just the ministerial ceremony of the designated officials reading and announcing the returns of the several states. That is, there is no indication that Congress conceived of the counting in this particular session as encompassing the power of dispute resolution. It is not unsound to theorize that it simply was not considered at this point that debates over the validity of electoral votes would ever occur, meaning that no dispute resolution process would have ever been thought about. Fourth, even if this may appear to be a little pedantic, it is of interest that the only joint session wherein the Senate Journal records the President of the Senate as having a role of counting the votes is also one of the only joint sessions wherein its presiding officer was a sitting member of the Senate, being collectively appointed by the Senate in preparation for the Electoral Count. Even if we are to accept that the Senate President counted the votes in this incident, he nonetheless would have appeared to be doing so whilst representing Congress, or rather at least one chamber of Congress. On March 1, 1792, Congress approved the first iteration of the Presidential Succession Act. Besides establishing the presidential line of succession, the drafters included several other provisions in the statute. Section 5 reiterated the counting clause, still retaining the ambiguity as to who the votes are to be counted by. And be it further enacted that Congress shall be in session on the second Wednesday in February, 1793, and on the second Wednesday in February succeeding every meeting of the electors, and the said certificates, or so many of them as shall have been received, shall then be opened, the votes counted, and the persons who shall fill the offices of President and Vice President ascertained and declared agreeably to the Constitution. In spite of the ambiguity of the above, several other provisions of the Act see Congress regulating the procedures of the Electoral Count in ways not explicitly enumerated as being in their constitutional powers. In Section 2, Congress directs that some electoral certificates be delivered to the judge of that district in which the said electors shall assemble. And be it further enacted that the electors shall meet and give their votes on the said first Wednesday in December at such place in each state as shall be directed by the legislature thereof. And the electors in each state shall make and sign free certificates of all votes by them given, and shall seal up the same certifying on each that a list of the votes of such state for President and Vice President is contained therein, and shall by writing under their hands or under the hands of a majority of them appoint a person to take charge of and deliver to the President of the Senate at the seat of government before the first Wednesday in January their next ensuing one of the said certificates, and the said electors shall forthwith forward by the post office to the President of the Senate at the seat of government one other of the said certificates, and shall forthwith cause the other of the said certificates to be delivered to the judge of that district in which the said electors shall assemble. In Section 3, Congress directs state governors to produce certificates which name the appointed electors in their respective states, and that the respective electors submit these certificates alongside their votes. And be it further enacted that the executive authority of each state shall cause 3 lists of the names of the electors of such state to be made and certified, and to be delivered to the electors on or before the said first Wednesday in December, and the said electors shall annex one of the said lists to each of the lists of their votes. In Section 4, Congress grants the Secretary of State the power to request a copy of the state's electoral votes from a judge of that state's respective district court in the case that the vote had not otherwise been delivered. And be it further enacted that if a list of votes from any state shall not have been received at the seat of government on the said first Wednesday in January, that then the Secretary of State shall send a special messenger to the district judge in whose custody such list shall have been lodged, who shall forthwith transmit the same to the seat of government. That Congress could go unchallenged in passing legislation that so clearly goes beyond their explicitly granted constitutional powers over the vote count could imply that the understanding of this Congress aligned with Article 2's purported implicit granting of their role in regulating how the vote shall be counted. The relevance of the statute would remain when it was retained and further supplemented by the 8th United States Congress in 1804, less than a year after that same Congress had approved the replacement of Article 2 with the 12th Amendment. In contrast to the Electoral Count of 1797, the Senate Journal did not make mention of the President of the Senate counting the votes for President during the joint session occurring after the 1792 presidential election, which was another unanimous victory for President Washington. The Journal rather implies that the votes were counted by the tellers appointed by Congress. The two houses having accordingly assembled the certificates of the electors of the 15 states in the Union, which came by express, were, by the Vice President, opened, read, and delivered to the tellers appointed for the purpose, who, having examined and ascertained the votes, presented a list of them to the Vice President, which list was read to the two houses. The presidential election of 1796 was the first time that the office was genuinely contested, with the Conservative Vice President Adams competing against Liberal former Secretary of State Thomas Jefferson. After Adams' victory was secured by a narrow margin of 3 electoral votes, some pro-Jefferson newspapers began promoting a conspiracy theory that the 4 electoral votes from the state of Vermont, which had been delegated to Adams, were not legally cast. This theory was based on a series of claims. 1. That Vermont's law that authorized the procedure by which electors were appointed had expired after 1792. 2. That the appointments were invalid because they were made through a resolve rather than a formal legislative enactment. 3. That Vermont had not appointed its electors within 34 days preceding the first Wednesday in December, as required by federal law. These accusations were simply not true. Vermont's elector laws had not expired, the state's electors were appointed according to those laws, and there is no evidence that their appointments occurred before the required timeframe. Jefferson himself did not care for any of these theories and dismissed them as fanciful in a letter to James Madison. I observe great doubts are still expressed as to the validity of the Vermont election. Surely, in so great a case, substance and not form should prevail. I cannot suppose that the Vermont Constitution has been strict in requiring particular forms of expressing the legislative will. As far as my disclaimer may have any effect, I pray you to declare it on every occasion foreseen or not foreseen by me, in favour of the choice of the people substantially expressed, and to prevent the phenomenon of a pseudo-president at so early a day. Although it has been suggested by some that Adams, as President of the Senate, asserted a unilateral power to count these supposedly contested votes, the historical evidence instead shows that the joint session occurred along the same lines as it did in 1793, with the tellers selected by Congress counting the votes. For every state, the electoral certificates were handed to the tellers, who noted their contents. All the returns having been gone through, the tellers reported that they had performed the business assigned to them and reported the result. Adams then announced the final vote totals to Congress by the report which had been made to me by the tellers appointed by the two houses to examine the votes, and declared that he had won the election in obedience with the Constitution and law of the United States and to the commands of both houses of Congress. The record is straightforwardly contrary to any unilateral method of dispute resolution. On February 14, 1800, Senator James Ross of Pennsylvania introduced a bill prescribing the mode of deciding disputed elections of President and Vice President of the United States, which is now often referred to by the shorthand of the Grand Committee Bill. In line with this title, the bill would have had Congress establish a committee with the power to inquire, examine, decide, and report upon the constitutional qualifications of the persons voted for as President and Vice President of the United States, upon the constitutional qualifications of the electors appointed by the different states, and whether their appointment was authorized by the state legislature or not, upon all petitions and exceptions against corrupt, illegal conduct of the electors or force, menaces, or improper means used to influence their votes, or against the truth of their returns or the time, place, or manner of giving their votes. Senator Charles Pinckney of South Carolina objected to the bill, although he acknowledged that it is indeed Congress's duty to count over the votes in a convention of both houses, and for the President of the Senate to declare who has the majority of the votes of the electors so transmitted. He believed that this role was purely ceremonial, that it never was intended nor could it have been safe in the Constitution to have given to Congress thus assembled in convention the right to object to any vote, or even to question whether they were constitutionally or properly given. Pinckney then believed that the Electoral Count was merely an uncritical formality of tabulating the several states' submitted certificates. At no point did he argue that the power to reject any vote lied within the presiding officer. The Senate passed the bill in spite of Pinckney's objections. It would later die after the House and Senate were unable to agree upon which chamber's draft would be adopted. In spite of the Act's failure to become law, it nonetheless reinforced the notion that Congress historically believed itself to hold the role of counting electoral votes. Neither chamber's version of the bill contradicted this notion, and even Senator Pinckney agreed that there was some congressional role in the vote count, if a limited one. Just like the Presidential Succession Act, the two houses passed their respective versions of the bill just a few years prior to the adoption of the 12th Amendment, thereby serving as precedent as to what a reasonable reader may interpret as said amendment's original public meaning of the vote shall then be counted. As an aside, while Congress was debating the adoption of this bill, Vice President Jefferson was writing his very own blueprint for a bill for settling disputed presidential elections in his personal manuscripts. In that draft, Jefferson felt entirely comfortable in stating that it is most reasonably inferred that by Article 2's direction that the President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and that the votes shall then be counted, that the electoral votes are to be counted by the members composing the said houses and brought there for that office, no other being assigned to them. This anecdote should be kept in mind for the next section. The 1800 presidential election saw a rematch between President Adams and Vice President Jefferson, with the latter securing a margin of 3 electoral votes over the minimum of 70 needed to win. The electoral certificate for the 4 votes of Georgia, a state won by Jefferson, was somewhat unusual. The affirmation of the electors' authenticity, to show that they were the legal electors rather than some imposters, was inscribed on the outside envelope that the certificate was contained in, rather than on the certificate itself. Although it has been argued by some that this slight irregularity made Georgia's certificate illegal on its face, the historical record shows that there was no particular controversy over these votes, and that they were counted by Congress in the ordinary manner. The joint session of Congress, the last to occur before the ratification of the 12th Amendment, took place on February 11, 1801. According to the Annals, Jefferson proceeded to open the certificates of the electors of the several states, and as the votes were read, the tellers on the part of each house counted and took lists of the same, which, being compared, were delivered to the President of the Senate. No congressman ever contested the validity of these votes, and Jefferson did not purport to assert any personal unilateral power to count them. I do not wish to spend much time looking over electoral counts that occurred past the ratification of the 12th Amendment, since my intention is to understand what the public meaning of that amendment was at the time of its adoption, not since. I will only examine a few more counts which I feel are worth illuminating. The Electoral Count of 1805 was conducted during a session of the 8th United States Congress, the same legislature which ratified the 12th Amendment the previous year, who on this day adopted a joint resolution adopting a set of tellers for the purpose of making a list of votes for President and Vice President of the United States, as they shall be declared, and that the results shall be delivered to the President of the Senate, who shall announce the state of the vote. After the President of the Senate, Aaron Burr, announced that the tellers will now proceed to count the votes as the Constitution and laws direct, they counted and took lists of the votes, which, being compared, were delivered to the President of the Senate. Aside from 1789, the Electoral Count of 1809 was the only time wherein an official recording of the proceedings described the President of the Senate as having counted the electoral votes. The Senate Journal of the Times recorded that the President of the Senate pro tempore did, in the presence of the Senate and House of Representatives, open all the certificates and count all the votes of the electors for a President and Vice President of the United States. On the other hand, the House Journal instead recorded that the tellers on a part of each house counted and took lists of the votes. This accounting of events is corroborated by the Annals of Congress describing the tellers as having examined and ascertained the number of votes. The reason for this discrepancy between the two journals is likely just that not very much thought had seemed to be placed into conceptualizing which entity executes this part of the electoral process. For there seems not at this time to have been much of a reason to care for an answer to this question. Being a landslide election for James Madison, there was not much room for any dispute over a state's returns to materialize, just as with 1789. Although some have argued that the Electoral Count of 1961 demonstrates the usage of a unilateral rejection power by Senate President Nixon to reject electoral votes from Hawaii, the actual events that occurred on and leading up to that day convey the complete opposite of this claim, and indeed provide evidence in favour of the Congressional counting theory. After Hawaii's 1960 election day had passed, it was not immediately clear whether the state had been won by Vice President Nixon or Massachusetts Senator John F. Kennedy. Early reports from local Hawaiian newspapers indicated that the state had been won by Kennedy. However, after just over a week of internal struggle, including an initial audit of the ballots, it was finally declared that the state had been won by Nixon, with a lead of only 141 votes. On November 22nd, 2 weeks after the election had been held, Massachusetts lawyer Robert Gray Dodge filed the lawsuit Lum v. Bush on behalf of a group of Hawaiian Democrats. Dodge's complaint alleged that the election officials responsible for the tabulation of Hawaii's presidential votes had, by fault of human error, miscounted Hawaii's ballots to the degree such that it had resulted in the erroneous declaration of a Nixon Lodge victory in the state, when in actuality it may have been won by Kennedy. Dodge requested that there be a court-ordered recount of the presidential ballots within the precincts wherein tabulation errors were alleged. After hearing the case on December 12th, Ronald B. Jameson, the presiding circuit court judge, ordered that the presidential ballots of a number of the respective precincts that were requested be recounted over the following weeks. Nixon's lead over Kennedy would narrow over the coming days. On the 15th, Nixon led by only 38 votes. 2 days later, Kennedy overtook him by 21. By December 19th, the day of which the nominees to the Electoral College were scheduled to cast their votes, Kennedy was leading the recount by at least 55 ballots, prompting Judge Jameson to order that the recount be expanded to encompass the entire state. Acting Governor of Hawaii, James K. Aloha, had already certified Nixon's electors by November 28th, under the then modest understanding that they were the duly and legitimately elected candidates. In accordance with this prerogative, of which had not been rescinded, the Nixon Lodge electors convened at the Hawaii Capitol building on December 19th to sign and submit their votes. Moments later, the Kennedy-Johnson electors did just the same. Seeing their steadily growing lead in the recount, Hawaiian Democrats, in Dodge's description, were voting for Kennedy as a legal safeguard in case Kennedy should emerge the victor when the recount is finally completed. The Democratic nominees produced their own certificates, nearly identical in the use of language as those of the Republican electors, with both groups declaring themselves duly and legally appointed and qualified by and for the state of Hawaii. On the following day, Kennedy's lead continued to rise, reaching 71 ballots. The day after that, it was 80. By December 27th, Hawaii's recount had been completed, with Kennedy securing a victory by 115 votes. 3 days later, Jameson wrote his final judgment on the dispute. It is hereby further ordered, adjudged, and decreed that in said general election on November 8, 1960, in the state of Hawaii, the total number of valid votes for the nominees of the Democratic Party for presidential electors and alternate presidential electors was 92,410 valid votes, and the total number of valid votes for the nominees of the Republican Party for the presidential electors and alternate presidential electors was 92,295, and that in said general election no other person received a valid vote for presidential elector or alternate presidential elector. In accordance with Jameson's ruling, Hawaii Governor William F. Quinn issued a new certificate of ascertainment for the Kennedy-Johnson electors, thereby retroactively affirming the description of duly and legally appointed, as their own words proclaimed. When a joint session of Congress convened on January 6, Vice President Nixon, in his role of President of the Senate, was the individual tasked with presiding over the counting of the electoral votes of the several states. In case of the scenario that Nixon would attempt to have certified his own electoral votes that were previously approved by Acting Governor Kealoha on November 28th, folders of documents containing pre-prepared arguments for an objection to this action were brought to the Senate floor by Hawaiian Democratic Representative Daniel Inouye and Hawaiian Democratic Senator Oren Long. Hawaii's Republican Senator Hiram Fong did not plan to object to the certification of Kennedy's votes, nor support the certification of the Nixon Lodge votes. When the moment came, Nixon announced to the joint session, "The chair has received 3 certificates from persons claiming to be the duly appointed electors from the state of Hawaii. The chair will hand these certificates one at a time to the tellers, who will read the certificates and the attached papers in full." Presented to Congress were the respective certificates of both candidates' electors, alongside the certificate of ascertainment signed by Governor Quinn 2 days prior. Following this, the ruling of Judge Jameson was presented to the sitting congressman. Nixon continued, "The chair has knowledge and is convinced that he is supported by the facts that the certificates from the Honorable William F. Quinn, Governor of the State of Hawaii, dated January 4th, 1961, received by the Administrator of General Services on January 6, 1961, being Executive Communication Number 215 of the House of Representatives, properly and legally portrays the facts with respect to the electors chosen by the people of Hawaii at the election for President and Vice President held on November 8, 1960. As read from the certificates, William H. Dean, Delbert E. Metzger, and Jenny Wilson were appointed as electors of President and Vice President on November 8, 1960, and did, on the first Monday after the second Wednesday of December 1960, cast their votes for John F. Kennedy of Massachusetts for President and Lyndon B. Johnson of Texas for Vice President. In order not to delay the further count of the electoral vote here, the chair, without intent of establishing a precedent, suggests that the electors named in the certificate of the Governor of Hawaii dated January 4, 1961, be considered as the lawful electors from the state of Hawaii. If there be no objection in this joint convention, the chair will instruct the tellers, and he now does, to count the votes of those electors named in the certificate of the Governor of Hawaii dated January 4, 1961, those votes having been cast for John F. Kennedy of Massachusetts for President and Lyndon B. Johnson of Texas for Vice President. There were no objections to the certification of Kennedy's votes, and as such, Vice President Nixon proceeded to preside over the certification of his own election loss in the state of Hawaii and of the several other states. Notice the language that Nixon used. He suggests that the electors be counted only if there be no objection in this joint convention. He did not decide, he did not dictate, he did not claim to hold any sort of power to count the votes by virtue of his position as President of the Senate. He merely suggests that they should be counted by a Congress which he believes holds the power to make an objection in this joint convention. Nixon knew that Congress was to count the votes, as did those representatives who anticipated that they might raise an objection to the counting of the Republican electoral votes. There are no ambiguities as to who did what on this day. The United States Supreme Court has occasionally mentioned a counting clause in its rulings. The 1890 case in Re Green describes that Congress has regulated the manner of certifying and transmitting the electors' votes to the seat of the national government and the course of proceeding in their opening and counting them. In 1976, the court wrote in Buckley v. Vallejo that the method by which Congress resolved the celebrated disputed Hayes-Tilden election of 1876 supports the conclusion that Congress viewed the 12th Amendment as conferring upon its two houses the same sort of power, judicial in character, as was conferred upon each house by Article 1, Section 5, with respect to elections of its own members. Justice Breyer wrote in his dissent for Bush v. Gore, 2000, that the 12th Amendment commits to Congress the authority and responsibility to count electoral votes. This characterization of the joint session was not contested by the majority opinion. Schiaffolo v. Washington 2020 uses familiarly ambiguous language when opining that the 12th Amendment then tells the electors to meet in their states, to vote for the President and Vice President separately, and to transmit lists of all their votes to the President of the United States Senate for counting. In Trump v. United States 2024, the court's majority wrote in passing that Congress may prescribe when the state-appointed electors shall meet, and it counts and certifies their votes. Although none of this is equivalent to a full court ruling rejecting URP, the comfort with which the justices adopt the Congressional counting theory's framing is to some degree suggestive of its legitimacy. The jurist James Kent wrote the following in the first volume of his Commentaries on American Law. The Constitution does not expressly declare by whom the votes are to be counted and the results declared. In the case of questionable votes and a closely contested election, this power may be all-important, and, I presume, in the absence of all legislative provision on the subject, that the President of the Senate counts the votes and determines the results, and that the two houses are present only as spectators, to witness the fairness and accuracy of the transaction, and to act only if no choice be made by the electors. Kent's presumption is just that, a presumption. He cites no evidence to support it. Even if we decide to adopt this presumption, it is already conditioned on the absence of all legislative provision on this subject. This means that any statutes which spell out Congress's role during the counting session, such as the Electoral Count Act, would override the presumption of the Senate President's alleged power over the deliberations. David A. McKnight, in his book The Electoral System of the United States, writes that, from the time of the first Congress in 1789 to the year 1821, history shows that the unquestioned custom was for the President of the Senate to declare the votes officially, whilst counting was, what the language of the law would seem to convey clearly enough, simply enumeration. The only evidence that McKnight cites for this claim is the Electoral Count of 1789. This evidence is flawed for the reasons previously stated in its own respective section. Historian Alexander Johnston's article Electors and the Electoral System, included within the second volume of Cyclopedia of Political Science, Political Economy, and a Political History of the United States, claims that the intention of the system was that the President of the Senate should canvass the votes, in accordance with a general authenticating law if Congress would or could pass such a law, otherwise, according to his own best judgment. From 1789 to 1821, there is no instance of a declaration of the electoral canvass by any other power than the President of the Senate. The only evidence that Johnston cites for these claims are the Electoral Count of 1789 and the ceremonial letters sent to the President-elects and Vice-President-elects to notify them of their respective vote certifications. Using the 1789 count as evidence is flawed for the reasons previously stated in its own respective section. Historian Charles Tencel, in his article Congressional Control of the Electoral System, writes, "In the early days of our government, the opinion widely prevailed that the determination of the electoral votes of the states was vested in either the state governments or in the President of the Senate." The sources cited by Tencel to support this claim are Johnston's article and a debate surrounding the 1800 Grand Committee Bill, which are both flawed for the reasons previously stated in their own respective sections, and John Hampton Dougherty's The Electoral System of the United States, a separate book from McKnight's, which itself just again cites the works of McKnight and Johnston, and of the Annals record of the Grand Committee Bill debate. In John Eastman's December 23, 2020 memorandum for the Trump campaign, he makes reference to the idea that constitutional law scholar Lawrence Tribe, in 2001, conceded that the President of the Senate might be in charge of counting the votes. Eastman was likely referring to Erog V Hsub, that's Bush v. Gore spelled backwards, and its disguises, an article that Tribe wrote for Harvard Law School, which was also cited in Chesebro's November 18th memo for the Trump campaign. In that article, Tribe writes that the issue of who has the legal authority to count electoral votes on January 6 is a complex question on which the text, structure, and history of the 12th Amendment are, it seems fair to say, less than decisive. In addition to this, however, Tribe also wrote that the conclusion that the power to determine contests over competing electors or electoral states rests with the two houses, and there is no other constitutional tribunal, tracks the plain language of the 12th Amendment and of Article 2 before it. Chesebro's December 13, 2020 memorandum made multiple references to a December 2019 article written by election law scholar Edward B. Foley, titled Preparing for a Disputed Presidential Election, an Exercise in Election Risk Assessment and Management. The article's purpose was, presciently, to consider the possibility that a major dispute over the outcome of the 2020 presidential election could arise. Among those considerations, Foley dwelled upon the possibility of the President of the Senate attempting to assert an alleged unilateral power to reject the winning candidate's electoral votes, and of the constitutional legitimacy thereof. Foley articulated the same arguments as Chesebro regarding whether Congress is able to act jointly, and of the potential of a stalemate between the two chambers. Foley also discusses the counterview that the necessary and proper clause enables Congress to regulate the counting of the vote, describing it as having had more adherents throughout history than the alternative. Although he does not mention it in the article, this soft version of the congressional counting theory is that which Foley himself adheres to. The Constitution Annotated, a publication prepared by the Congressional Research Service, falsely states in its explanation of Article 2 that, in the presence of the Senate and House of Representatives, the President of the Senate would then count the votes. No citations are provided to justify this interpretation of the text. There is no mention of who holds the role of counting the votes in its separate explanation of the 12th Amendment. A February 27, 2020 Office of Legal Counsel memorandum, which was made available to the public during the final days of the Biden administration, states that the President of the Senate opens the certificates and counts the votes in the House of Representatives, with all the members of Congress present on January 6. The only sources cited for this claim are the 12th Amendment and the United States Code Title 3, Section 15. Neither of these sources provide evidence to support the memo's words. The only non-negligible pieces of evidence that support the purported soundness of the unilateral rejection power theory have been the official records of the 1789 and 1809 electoral counts. The first count is of limited value, for it was of an uncontested election still held under Article 2, wherein an otherwise ordinary senator was appointed by a House of Congress as president pro tempore for the purpose of facilitating a seemingly ceremonial process of counting each state's returns. The recording of the Senate president as having counted the votes in 1809 appears to be little more than an error made only within the Senate Journal and not within that of the House of Representatives or the Annals of Congress. All other pieces of supposed supporting evidence in favour of URP consist either of 1. Critiques of the Congressional theory of counting, which do not by virtue of their accuracy make the simultaneously accurate critiques of URP somehow disappear. 2. Very poor, sometimes perhaps deliberately so, misreadings of the events that happened around past electoral counts, such as those of 1797, 1801 or 1961. Simply put, the best interpretation as a matter of text, and the better interpretation as a matter of history, is that the counting function is vested in the Senate and House of Representatives. My slightly accusatory tone in that second point segues into something that I have tried to refrain from expressing until this moment. Those who advocate for the apparent constitutionality of the URP appear to do so for wholly political reasons, not as part of a genuine attempt at interpreting the Constitution. In a court filing that motioned to dismiss his prosecution in 2023, Kenneth Chesebro stated that the 12th Amendment vests Congress alone with the power to receive, adjudicate, and count presidential electoral ballots or returns. That is, Chesebro adopted the complete opposite position to that which he argued for in his Trump campaign memos. Similarly, all the way back in 2000, John Eastman testified before the Florida state legislature that American law
gives to Congress the power to be the ultimate judge
in regards to
how Congress is going to vote or count the votes that it receives.
Eastman maintained this position even as late as October 2020, commenting on the draft letter to President Trump that he disagreed with the position that the President of the Senate decides authoritatively what certificates from the states to open and what electoral votes are counted under the 12th Amendment and the Electoral Count Act, stating that the 12th Amendment only says the President of the Senate opens the ballots in the joint session and then, in the passive voice, that the votes shall then be counted. United States Code Section 12 merely states that he is the presiding officer, and then it spells out specific procedures, presumptions, and default rules for which states will be counted. Nowhere does it suggest that the President of the Senate gets to make the determination of his own. Even after having changed his position on the counting clause, Eastman would eventually admit during an argument with the counsel to the Vice President, Greg Jacob, that his plans for the presiding officer to reject votes during their electoral count would lose in a 9-0 ruling if it ever became a case put before the United States Supreme Court.
We had an extended discussion, an hour and a half to 2 hours on January 5th, and when I pressed him on the point, I said, John, if the Vice President did what you were asking him to do, we would lose 9-0 in the Supreme Court, wouldn't we? And he initially started it, well, I think maybe you would lose only 7-2, and after some further discussion acknowledged, well, yeah, you're right, we would lose 9-0.
URP is not a serious legal theory. Rather, it is a vehicle constructed for the usurpation of the classically liberal and republican principles of which America's constitution and culture have been built upon, to be replaced by a new establishment with direct hostility to those said values. Irregardless of the insincerity of this essay's namesake, there is certainly a valid arena for differing opinions as to whether Congress's role of counting their electoral votes is ministerial or discretionary, and as to what entities, if any, may deliberate over any disputes that may arise over the authenticity of those votes. I myself believe that the usage of the Senate and House of Representatives, rather than the Congress in the 12th Amendment, and of the said amendment's failure to explicitly grant any deliberation powers upon Congress, indicates this role to be a ministerial one. This feeling is further bolstered by the ceremonial nature that each electoral count prior to the amendment's ratification seemed to inhabit. Any dispute over the returns, in my eyes, seems most appropriate to be resolved by appealing to the courts for a verdict, as was done with Judge Jameson's ruling back in 1960. This essay is not comprehensive, and my opinion here should by no means be seen as conclusive. There have been several legal scholars who have opined on this issue, all of whom should be taken more seriously than I should. I have been citing their works throughout this essay, all of which should be easily accessible for your own reading.